You co-own a property with your spouse and you pass away, your half of the property will not automatically avoid the probate process and go directly down to your surviving spouse. It depends on how you hold title to that property. It can either be tenants in common or joint tenants with rights of survivorship. Tenants in common is the default way that title companies or closing attorneys will set up the ownership of a property. And let's say you own 50-50 with your spouse and you have tenants in common and you pass away. It will have to go through the probate process, and it will go through probate and be distributed one of two ways. If you have a will, it will be distributed per the instructions in the will, which is typically going to your surviving spouse. If you do not have a will, it will get split up per the intestate laws. As an example, in Georgia, your assets will get split evenly between your kids and your spouse, with your spouse getting a minimum of 1/3. So your half of the house with tenants in common and no will get split up between all of your family versus it will not just go down to your surviving spouse. Now, if you have joint tenants with rights of survivorship, it will avoid the probate process altogether, and your half of the house will automatically go down to your surviving spouse. All they have to do is file a survivorship affidavit and your death certificate with the county clerk's office. They will process those documents and transfer your half of the property down to your surviving spouse. Now, if you have it as tenants in common and you want to update it, all you have to do is change it to joint tenants with rights of survivorship, and your property will avoid the probate process and go directly down to your surviving spouse. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.